All right. So, from what I understand, both sides have now rested in the Carmelo Anthony case, and closing arguments will begin tomorrow, Tuesday, June the 9th. What I found interesting, based off, again, just the news reports, because I have not been spending any time at the courthouse, is that the defense focused their strategy on rebutting whether Anthony was the aggressor and had a Frisco police officer go up to clarify that carrying a knife under 5 inches, actually under 5.5, but for their purposes, under 5 inches, was not illegal regardless of school policy stating that it was not allowed. Even though it's been widely reported that the defense had multiple defense investigators, there has been no report of a defense investigator taking the stand either to rebut previous testimony from another witness or to admit any additional evidence, whether it be electronic evidence or some kind of impeachment evidence against one of the witnesses or even against the alleged victim or complaining witness in this case. It is not necessarily a requirement, and every case is different. I have certainly sat inside the courtroom as an expert and not been called to substantiate the admissibility of evidence that I uncovered if defense has determined that it wasn't needed. And likewise, I have sat in court and sat outside the court when the judge ruled that I was subject to the rule. And by the way, the rule is the rule of exclusionary witnesses. And not being called to testify to rebut anybody. It could be that all the witnesses, if they were interviewed by the investigator for the defense, said the same statement or substantially similar statements as they did to police and as they testified in court. It could be that the teenage witnesses and or their parents did not allow a defense investigator to interview them. Concerningly, it could also mean that the defense investigator didn't make the effort to interview or was instructed not to do any interviews. On these investigations, particularly in cases with criminal cases, the investigator is really subject to the whims of the defense attorney because he works for the attorney. He does not work for the accused. So whatever the attorney deems is in the best interest of the case and the best interest of their client, then that is what the investigator is going to adhere to, or at least should adhere to. After all, the defense investigator's work product is the attorney's work product. So, there could be any number of strategies amongst the defense attorney or attorneys, since there are two, that preclude the investigator from conducting the interviews. It could have been a matter of, again, there wasn't anything to rebut, wasn't any new evidence, or simply certain steps weren't taken and the investigator wasn't deemed necessary. But a defense investigator was not called to the stand. The only investigator called by the defense was a Frisco police officer who may or may not have been a CID investigator. And again, that was only to rebut the assertion that it was illegal to carry a knife under 5.5 inches on school property.